inclusive and resilient economy. And to give a bit more insight into this, we'll have 3 presentations. One by myself, looking at performance of competition amid the pandemic, noting that the pandemic has been with us for the past almost 2 years now. And then we'll have a second presentation by the Consumer Unity Trust and Trust Society, that will be led by Mr. Peter Mwencha, who is a board member with that society, and we'll be looking at competition principles for resilience during the pandemic period. And then we'll have the competition authority represented by Boniface Makongo, looking at enforcement challenges and competition. So I'll just give a brief background as to the topic for today as we delve into the webinar. So feel welcome. There is a chat box. Firstly, give some housekeeping rules. There's a chat box to which you can post your questions as we move along. Then any of our presenters will look at them and then answer accordingly. And then we request all our participants, while the presenters are on, please keep your cameras turned off and your microphones as well. I will have an opportunity during the plenary to raise your hand and ask your questions, and we'll attend to them accordingly. So let me delve right into it. So I'll give my presentation now. So just a second as I load it up. Is that viewable for everyone? Hello?
Steve, go ahead. We can hear you.
All right, thank you. So as I've mentioned, in commemoration of the World Competition Day to be held on the 5th of December, which will be a Sunday, we're holding this webinar, and the theme for this is the competition policy for an inclusive and resilient economy. So the outline of my presentation is, as you can see, what is it about the World Competition Day? So of the World Competition Day, and then I'll give a brief introduction to what competition is, and then within the Kenyan scenario, what guides competition, and that's the Competition Act 2010, and I'll just look at the objective broadly, and then we look at the importance of competition law, and then insofar as consumer welfare is concerned, and then we'll delve into the perspective of the pandemic now, the challenges that came about amid the pandemic. So I'll have just 2 slides on that, 1 and 2. And then I'll just give a sample of the areas that are affected because they traverse all the sectors of the economy. And then we look at how competition policy came into play just to ensure that consumer welfare is enhanced. And then I'll just give a brief conclusion. So about the World Competition Day, probably we know in the world we have days, every other day being commemorated. Like on the first, just 2 days back, was the World AIDS Day. So, and I think yesterday was the World Disabilities Day. On the 5th of the World Competition Day. And how did this come about? About 1980, the Consumer Unity and Trust Society proposed that the 5th day of December be adopted and be commemorated as the World Competition Day. And this came to pass by the adoption of by the United set of competition policy. This encompasses a host of rules and regulations that guide competition, competitive environment in different states and in different countries, and all those that actually sign into the United Nations Treaty. The reason why we recognize the 5th of December as World Competition Day is to actually internalize the need to promote competition reforms globally, because that actually works to the benefit of you and me as consumers. And also, secondly, that ties to the first principle, and then for effective implementation of competition regimes across the globe. So that's basically it. Because competition actually works and is supposed to work for the benefit of consumers. That said, how does the competition policy look like in Kenya? So for the Kenyan scenario, competition is guided actually by the Competition Act 2010. It has had some amendments, latest being 2016. Just to give you a brief background for those probably who are interacting with competition for the first time, what does the law say in terms of competition? So it states that competition is a process where two or more persons, okay, supply or attempt to supply to or acquire or attempt to acquire from the people in a given market the same or substitutable goods or services. That's what the law says. It further goes on to say that a market means a market in Kenya. And this was interesting for me as well. A market in Kenya or a substantial part of Kenya. Perhaps there's need to look at what substantial part of Kenya means, but that's a story for another day. So substantial part of Kenya and refers to the range of reasonable possibilities for substitution in supply or demand of a particular product or service. Okay, so that's insofar as that is concerned. So that's what we are looking at in totality. Competition, what it says, and the market as it is. So what are the objectives of this particular Competition Act? Firstly, is to promote and safeguard competition in the national economy. National means Kenyan economy. Also, to protect consumers from unfair and misleading market conduct, which are numerous if you look at the law, and also provide for the establishment, powers, and function of the Competition Authority. And I'm happy we have someone from the authority who will speak more to this, and the Competition Tribunal, and for connected purposes. That's what the law says. So other than that, what does it stand for? What does the Competition Act establish rules for? So it establishes rules for establishment of the Competition Authority, one. It also looks at perspectives and areas for restricted trade practices, which includes dominance and more so abuse of dominance. We can speak more about that, but that will come on later. It also looks at issues of mergers and acquisitions and aspects of economic power of a particular market player. It safeguards consumer welfare and also provides for the formation of the Competition Tribunal. Right. So these are just the areas within which the Competition Act operates. So these are like the sub areas. They're like six sub areas within the Competition Act. So that's that. So now let's look at the areas that probably Competition Act comes into play. So I'll just give a few examples of the areas that were affected during the pandemic period. So as you can see, I've mentioned the transport industry. You remember very well when the Ministry of Health issued guidelines together with the Ministry of Transport that gave restrictions that meant that travel intra-county were prohibited. You couldn't travel from here, let's say, to even Nakuru or to Mombasa. That's the effect of the pandemic. we noticed. In the same vein, even across borders, we noticed you couldn't travel abroad, and that's a reality, and that actually is something we noticed. The pandemic also affected food distribution. That came into play. We witnessed a bit of disturbance here in Nairobi. Also, in terms of product distribution, and this I want to speak per se to vaccination and testing, because we realized that for vaccinations, initially, and I'll speak to this more in detail in the next slides. Initially, you had to probably get your sample taken to South Africa for testing, and then get it back for you to actually be able to conduct or travel whatever business you wanted to. We noticed aspects of intellectual property in terms of vaccine production. That curtailed competition, because if you patent your product, or you're not able to give information on production of the vaccine, or share how you produce, then that has an effect on the competitive environment. And then most of us witnessed the issue of availability of quality protective masks, also the so-called PPEs. And now we just getting masks. If you walk right across town, you just get a mask for as little as 10 bob. Whereas last year, when the pandemic struck, we were getting the masks at a high of 150 Kenya shillings. That's about $1.5. Right. So let's look at the application, or how competition came through, just to ensure competitive policy environment came through to ensure that we're able to move on, or to ensure that the resilience of Kenyans, or of persons who are so to speak, consumer welfare was enhanced. So I'll speak to vaccination first. There are a number of vaccines available, and the production levels have been going up over the past year, and they are available in various types. So one of the programs that the IEA runs is public finance management. They did a simulation on the cost of vaccines, and I'll just give you a sneak preview. I can share the details later. You can go to our website and interact with that. So the most expensive vaccine is Moderna, which goes as $25, followed by Pfizer, which goes for by Sinopharm, which goes for $20. And then Pfizer, which is $18, Johnson & Johnson, $10, and then the cheapest, which I think most of us, if you reside in Kenya, have gotten vaccine of, is AstraZeneca, which is just $6 for a vaccine. So the reason I'm mentioning this is because the perspective of competition comes into play to ensure that we have a variety to choose from. And for those who are price sensitive, of course, if a vaccine works well and it's been proved to be okay, then regardless of the cost, you might want to go for the cheapest as long as it meets your objective. So the competitive environment allowed that the flourishing of the production of various vaccines for various markets, thus ensuring that consumer welfare is enhanced. And that also comes into the second aspect is the cost we are talking about. just to take us back to sometime, I think early this year, when we had the Sputnik virus come through, and that was just for the quote unquote chosen few. It was very expensive, to be honest, if you are to look at it from the lens of from Russia. It was coming from Russia and it was very expensive. It was just for the chosen few. But being that there were other available vaccines, then meant that the common mwananchi was able to actually access vaccination, and which was relatively affordable. And you remember, actually, even as at now, we still have free vaccination for all Kenyans, unless you want to pay. That's individual choice. Then testing centers. Initially, we had isolated centers for testing, and you could go and pay, but noting the perspective of now ensuring that we want to get herd immunity as soon as possible, then we had a widening of testing, and more testing centers were introduced, and that meant that it was now much more affordable. And then we're looking forward to having many more Kenyans getting tested for COVID. And then, of course, I've mentioned the mass production lowering costs, leading to consumer benefit. So that's just one aspect of how the competitive environment allowed enhancement of consumer welfare, which is actually one principle of competition. And then I look at the second area, which is just the transport industry. And as I was saying earlier on, the restrictions that were meted on in the transport sector actually came to be a detriment to the entire sector. We noticed a couple of buses or circles actually closing down. Some had their buses or matatus just idling around because of the restrictions that were came through because of the from the Ministry of Health with the Transport Ministry as well. And we can remember the directive or regulation that we needed to just carry half a matatu had to carry half of the seating capacity, and also ensure that there's social distancing therein. This affected the industry, the matatu industry, and we witnessed just in the couple of months that the curfew and restrictions have been lifted, arriving or a clawback of competition. And I'll give an example. Earlier this year, if you were to travel to say, let's say Mombasa, it would have cost you perhaps 2,000 Kenya shillings by bus. For example, right now, because of the easing of restrictions and coming back of other matatu sector players within the same route or route, as you want to say, we've realized a reduction in the pricing on the cost of in the fares to and from, let's say, the city of Mombasa, and that we can tie to the effect of the competitive environment that has been enhanced due to the lifting of those restrictions. Yes, the effect of food distribution, noting that the borders were closed and some of our imports come from our good neighbor of Uganda and Tanzania, we realized an increase in food prices, marginally though, but that also is an effect. But now that the restrictions have been eased, then we realize that the prices are normalizing back to their normal levels. And then, of course, the effect on the airline industry that can be gainsaid. We couldn't travel out of the country, even intra-county travel were restricted, and that was actually a detriment to the competition within the industry. So having said that, let me just give a short conclusion as I allow the next speaker to come on board. So in conclusion, what I want to say is that the effects of the pandemic on the competitive landscape are actually numerous. I've just given a few examples. But there's need to notice that resilience and application of competition policy ensures that consumer welfare is actually enhanced. And lastly, is that they need to ensure that at all times, the competitive landscape is premised on enhancing consumer welfare. And that's what we actually look forward to. So I'll stop there for now and allow our second speaker, Mr. Peter Mwencha, who is a distinguished guest and also a board member at Consumer Unit and Trust Society, to come on board and give his presentation.
Thank you, Stephen. Can you hear me? Am I clear?
Yes.
No. Okay, thank you. Let me just share the slide and then can you, I'm sharing, can you see it?
I guess it's loading. Yes, it is. Go ahead.
So you can see it?
Yes, we can. Go ahead.
Okay, great. Okay. Yes, Asia, good morning, everyone. As you've heard, my name is Peter Mwencha. I am a university professor, but I'm also a director at the Consumer Unity at Trust Society. So my presentation today will be titled Competition as a Guiding Principle in the Adoption of Measures for Economic Recovery During and Post-COVID-19. And so this is going to be, I'm not going to be my presentation. Stephen has given a very detailed presentation on the Consumer Act and the specific, he's gone the specific provisions in the Act with regards to competition, and has also gone to give cases whereby competition has been used during COVID, whatever pandemic. So in my presentation, I'm going to take a slightly different approach. I'm not going to go into really the legal side of it that much like he has done. I'm going to focus more, as the title says, on the principles that are employed in when interpreting or when applying the competition policy and also the Competition Act. But I'm also going to look at how this can be implemented, not just during during this period when we are exiting the worst phase of the pandemic, but also in future. What are the implications and what are the options, policy options that the government has, and also other stakeholders? What exactly do we expect, and how can this be done? So, like I said, I'll start. So as you can see, so I'll have like my presentation has 7 major areas. I'll try to go through them quickly because I'm told I only have 20 minutes. So I hope I can do this in 20 minutes time. So as Stephen mentioned, competition plays a very important role in ensuring a well-functioning market, especially now that we have COVID-19, which has disrupted economic activity in the country. But the problem now we're starting to see, or the problem we've been seeing, is that there's a lot of concerns about whether there's enough competition in various markets, because you have cases where a lot of players have exited the market. Some players are not able to, there's a lot of, as you'll see later in my presentation, we have a lot of cases of companies which are now insolvent or in trouble, and they're not able to perform like they were before. So these are all, it paints a very negative picture of in terms of competition, and even just the disruption of economic activity, like if you can see in sectors such as transport, in the leisure and hotels. So all this is cause for concern for those of us who are interested in competition. So my presentation, like I said, we look at the principles of competition policy, which are being enhanced, which are being employed to enhance economic growth during and the post-pandemic period. So what is competition in a nutshell? Competition means a situation where people are fighting for superiority, where one wants to be, I would call, dominant or superior to another. But in an economy like ours, competition is a process where firms fight against each other to secure consumers for their products. So this is just a very simplistic definition or explanation. And why should we care about competition? First of all, from a macro, broader perspective, competition is essential for national competitiveness. I think we are all familiar with the World Bank competitiveness report, which I think was stopped about some months ago. I think the World Bank said it will no longer publish the competitiveness report. But as you can see, national competitiveness is a big issue, and countries are all trying to be competitive or more competitive than the other in order to attract investments and to also to be to grow economically. So, but then now in a micro level, so on a macro level, like I said, competition is an essential condition for national competitiveness. And then at a micro level now, we can see competition being important for allocative and productive efficiencies. This is when it comes to now sectors. How do companies allocate their resources? How does the government decide how to allocate its resources? It fosters innovation. We're going to look at that as well. Enhances consumer welfare. I think this was mentioned before. Economic growth and development, and it also helps to uphold democracy. So we have fair and unfair competition, and that's why we and these are things now we through the Competition Act and also the Competition Authority. These are cases or situations whereby competition authority is tasked to determine whether companies are operating fairly or are competing fairly or are competing unfairly. And as you can see, there's a broad array of these cases. I like quality goods, where you produce quality goods, where you become efficient, but also and so on. But then the negative things are like price fixing, which is very common, and which is now sort of sometimes termed as cartel-like behavior, and also things like advertising that belittles other people's products. So there's so many of these unfair and unfair competition examples. I don't want to go into it in detail, but all I can say is that when you're competing, when companies are competing, or when businesses are competing, you can compete on price, whereby you offer a lower price, or you can compete on non-price aspects such as advertising, after-sale services, promotion tools. So some companies are better than others because they are able to combine these two aspects of competition and therefore capture a bigger share of the market than others, their competitors could. So this also goes now down to maybe business acumen and entrepreneurial acumen. And that's why entrepreneurship and innovation and research, all those things are important in competition, because you can't only compete on price, but you can also compete on these other factors. So two things when you're talking about competition: you have competition policy, which is like the broader aspect of it, whereby you look at the options that the government has in order to promote healthy competition in sectors or markets. So this, and then you've got, so competition policy in itself has two aspects. There's economic policy, whereby government is looking at things like the industrial development policy, and they're looking at maybe even export promotion. All these things are tied to some of the economic policies that form part of, you know, the broader competition policy. Then you have the competition law, which is a narrower, and this is now meant to stop anti-competitive practices, because if the government doesn't step into the market, sometimes the businesses may compete unfairly, as we have seen. So competition policy is broader in the sense that it has the economic policies that are shaped by government, but then it has these legal aspects which are designed to ensure that the market operates in the manner in which it is expected to behave, because we have cases of market failure or also anti-competitive business practices. So, and this is what you can look at. This is how we can look at it. As you can see from the blue, whatever, you can see competition law is an aspect of competition policy. So competition policy is the broader aspect of competition. And like I said, this is how government, whatever government measures or intervention government takes, or choices that government has to ensure that markets function as they should. And then we have competition law, which is now the legal aspect that ensures that the competition is actually, or the businesses are actually competing in a manner that they are supposed to. So, and as you can see, competition policy is very broad. You have aspects, you have so many aspects, from trade policy, like I said, things like export promotion and whatnot, SMEs, you can industrial policy, foreign direct investment, fiscal policy, intellectual property rights, labor. All these things are part of, or they also fall under competition policy. So competition policy has to also look at all these policies, and that's why competition is such a broad place and interesting place. So and then you can see, so this is the delineation, or this you can see you have the government policies on one side, which is now like we've seen before, and then you have the competition law on the other side. So I don't want to dwell so much on the competition law, because I think Steve has gone through it in a bit more detail. But these are the three main areas of competition law when you're looking at it. So we've got collusion between firms, we've got abuse of dominant position, and we've got also regulation of mergers to prevent dominance in the market. So these are the three broad aspects of competition law. So I want to skip to what we call competition principles, because this is what I want to focus on in my presentation. So competition principles is the interface between policies relating to, like you see, this is investments, concessions, industrial sector policies, basically where now, like we've seen before, where you have the competition policy on one hand, and these government policies, these other policies, economic policies on the other hand. So competition principles is the interface between these two, and it's the one that helps to ensure that competition law is applied effectively in this in these various contexts. So there are many competition policies, but I just want to talk about 9 of them today. So the first one is like fostering competitive neutrality, ensuring access to essential goods, and so on. So there's 9 of them. Let me just start by going to the first one. So here we have fostering competitive neutrality, which is principle 1. In this case, this is basically whereby a principle that looks at, or rather tries to ensure that the state or the government or does not favor any one sector or any business within an industry, and basically to ensure what we call a level playing field. So during COVID-19, during this COVID-19 period, we've seen the government come up with what we call a stimulus, although in my view, I was part of a team that did an analysis on the stimulus measures that the government announced during COVID-19. And to be honest, these stimulus measures did not do much to help SMEs weather the crisis or reduce failure rates. So there's a lot of, I think there's a lot of reasons why, from our analysis, the stimulus measures were not effective, but I don't want to go into the details. But you can see the result is that there's a lot of bankruptcies and a lot of businesses have closed because of COVID. So this just tells you every day when you look at the newspaper, you see a lot of auctions, bankruptcies, and I think even when you talk to people, they tell you, job losses. So this is basically a consequence of the ineffective government support measures during the COVID period. But then again, on the other hand, you see the government supporting other public enterprises or other state-owned enterprises like Kenya Airways, like Kenya Railways, getting a lot of money from the government. So you can see that perhaps this support has not been very objective or fair. Some SMEs have not gotten the support that they needed, whereas public enterprises have been getting support even before COVID. Many of these have not been doing very well, or some of them have not been doing very well, but the government has still continued supporting them. So the other thing that on how to foster competitive neutrality, a principle, is that you also need measures to lower trade costs and entry barriers in order to promote entrepreneurship and growth of MSMEs. So one of the things that, like the World Bank report on competitiveness, one of the things it looks at is things like taxation and entry barriers, and on investment, barriers to investment or to entry into a market. So in the Kenyan case, taxes have been very high. So it's one of the things we need to consider. How do we ensure that taxation does not stop investment? There's a lot of licenses also, which is a problem, duplication of licenses in certain sectors. So that needs to be rationalized. But one example I can give, a positive example, is the Kenya Competition General Rules by the Competition Authority, which reduced the filing fees for small and medium enterprises, which is a positive step forward, because otherwise it just increases the regulatory burden on these SMEs, which don't have a lot of resources. So this is a positive measure in that regard. So when you talk about ensuring access to essential goods and facilities, this principle, you can see, just as Stephen mentioned before, you can see that during COVID, a number of manufacturers and retailers either increased prices or hoarded goods which were essential, such as masks and sanitizers, because they wanted to make more money. Again, one of the ways this principle was enforced or was applied in the Kenyan case during the pandemic was this Competition Authority issued a cautionary notice against manufacturers who are colluding to increase prices. And also later on, there was a remedial order against a retailer who had been found to have raised prices unconscionably. So the retailer was asked to refund the buyers or the people who had, the shoppers who had bought these expensive tropical hand sanitizers. So this is an example of how like competition policy or competition law can be enforced to protect consumers and enhance consumer welfare. So the third principle is free movement of goods, services, and capital. Here in this case, in this principle, this is seen when we look at regional integration measures. I'm sure you're aware of the Africa Continental Free Trade Area, which is a massive free trade area on the African continent, which is expected to enhance intra-African trade. So this principle is, you can see now, it even now applies across borders, whereby now if you want goods and services to move freely, competition is, you also need competition to ensure that this companies that want to trade beyond the borders are not stopped, or people who want to come into your market from another market are not stopped. So this is a very good example of how the Competition Act or competition policies and principles also now apply beyond national borders. And but the problem is, as you can see in my second point, is that there's powerful lobby groups and there's powerful business groups and business people that may not want competition from outside the country. And this could be a problem because some of these groups are very powerful and they're benefiting from the current status quo. So as competition stakeholders, this is something that we've seen from time to time, and therefore enforcement of competition law is very important to ensure that when we now, either as Kenyans want to enter a different market, or even vice versa, when other people want to come into the Kenyan market, to ensure that we do not stop this from happening. So the fourth one is we need to separate policy making, regulation, and operational functions. So this has to do with clear institutional arrangements which delineate the roles of government policymakers vis-a-vis independent regulators. So in the past you had, before we had all these reforms on the deregulation of markets in Kenya, you would find that the ministry was the same one that was setting policy and doing the regulation, enforcing the regulations. You had departments in the government which were now acting as regulators. But nowadays we have, in Kenya at least, the laws were very progressive. Many sectors have independent regulators, which separates them from the government policymakers, which is a good thing. But there are still cases where you would find that sometimes government would make a policy that would perhaps interfere with the independence of regulators. So this is something that needs to be, this is a case-to-case basis, because like I said, in Kenya, to a large extent, regulators are there in most cases, and they're already, they're enforcing the laws, be it competition or whatever laws that they need to do. So this shrinking of the state or clear delineation of institutional arrangements needs to be respected, and is something that needs to be, there's need for more advocacy and awareness so that by regulators, in particular the Competition Authority, so that the government can, policymakers can understand. There's a lot of sensitization that is needed so that government policymakers going forward can understand that sometimes they may have policies, or they may come up with policies which have or could have a negative effect with regards to competition. So I don't want to go into the cases, but maybe in another forum, this is something that can be discussed. So, and this also ties to the operational independence of regulators, which is key. So as much as the part again of the other side of clear institutional arrangements is operational independence of regulators, whereby now somebody doesn't either interfere with the regulators, how they operate, maybe political pressure or some other type of pressure or capture, but also regulators should work together. As much as regulators are independent, they also need to work together through this, what we call the whole of government approach to policy making, in the sense that you don't want silos, like I said, we do have regulators in place in Kenya. In many sectors, regulators are there. So in this case, I'm looking at the financial sector, where you have, I think, 5 regulators. You have the central bank, you have the Capital Markets Authority, you have the SASRA for SACCOs, you have the Insurance Regulatory Authority. So what these regulators have done in the financial sector is that they've come together and under the Financial Sector Regulators Forum, and they've created what you call a regulatory bridge, which allows them to coordinate their policy measures, but also in terms of the regulation of fintech, because Kenya is renowned as a fintech hub, and some of these fintech companies, you would find their services or the services that they offer fall across different sectors. So you'd find Capital Markets Authority, they would need to go to the Capital Markets Authority for a license, then they would go to the central bank for a license, or maybe go also to the SASRA for a license. So the financial sector regulators in Kenya have come together with this through this approach to ensure that then regulation of this fintech is not cumbersome or onerous, so that it makes it easier for these fintech companies to operate in the country. So, which is a very positive step, and I think is something that should be, other countries have followed this model, and it's something other sectors in Kenya can also emulate. Sectors with multiple regulators can also emulate this. So principle 5 is ensuring a free and fair market process. Basically, Kenya has deregulated a lot of sectors and liberalization since we started liberalization. But then there are certain sectors which are known as strategic sectors, which are still government controlled, and particularly energy and transport. So, and we've seen that these sectors in Kenya, or certain parts of these sectors, energy and transport, like aviation, is to a large extent, the government has a very huge stake in the aviation because of Kenya Airways, and we have the Kenya Airports Authority, which is still owned by government. Then we have, like in transport, we have things like in energy, we have Kenya Power, KenGen, Kenya Pipeline. All these are government owned, and the problem here is that the government is not only a producer, but it's also a regulator, because there are also regulatory bodies in this space. So sometimes from a competition perspective, this is not this is not an ideal situation. If you look at many countries, especially in the developed countries, governments have largely privatized many of these entities. So the question is why the Kenyan government does not want to privatize, say, Kenya Pipeline or Kenya Airports Authority, or some of these public sector or public bodies which are government controlled and which are also doing business, but at the same time competing with the private sector.
Sorry,
so,
pardon? You should be winding up. Your time is...
Okay.
Yep.
Okay. Yeah, sorry, just 5 minutes and I'm finished. So so many of these lose money and they get subsidies from the government, so which is not a good thing. So something that we should think about. So let me move on to balancing competition and intellectual property rights. So intellectual property rights in Kenya have given a high priority, and there are 4 main types of intellectual property rights. So copyrights, patents, trademarks, and trade secrets. So in order to encourage competition, we have to protect intellectual property rights. And more importantly, under intellectual property rights and competition is innovation, because this intellectual property rights, they come about as a result of innovation. So going forward, Kenya companies, in order for them to remain innovative, and even as an economy or as a country, we need to invest in research and innovation in order to come up with our own intellectual property rights, so that we can also be able to compete. So the other principle is notification and public justification for deviation from competition principles. So, like I mentioned before, sometimes governments or industries or even businesses do deviate from competition principle, like in the case of where now public funds are used to bail out loss-making state corporations or state-owned enterprises. So how should the competition authority handle these government measures to support these bodies, whereas you've got other players in the market which are more efficient? So this conflict or this dilemma whereby government is supporting inefficient entities, but then you've got more efficient entities in the market that are not being supported. So this is not an efficient allocation or utilization of resources. And this shows the conflict between competition policy and industrial policy. And this is where, as a principle, this principle now comes in. How do you balance between this conflict between industrial policy and competition policy? So Principle 8 is ensuring transparent, predictable, and participatory regulatory environment. This has to do with competition advocacy, whereby now bodies such as starting with the Competition Authority and other stakeholders should spearhead the discussions and policy discussions in terms of with regards to competition, but also bring on board stakeholder. There's need for stakeholder involvement in policy making, which has happened in Kenya when the competition general rules were being debated and formalized, and then also making decisions public. So in the case of the Competition Authority, they publish their decisions in the Kenya Gazette and its website, highlighting the reasoning and the decision making behind the final decision. So this is something that should be encouraged, so that there's transparency and predictability in this environment. And lastly, respect for international obligations. So competition is not exclusively a national affair. Like I mentioned, we have the like now cross-border trade, where we now the single market that is being established, which is the Africa Continental Free Trade Area. So you can see even within the Africa Free Trade Area, Continental Free Trade Area, there will be competition between either businesses or countries or whatever. So how do you ensure that this competition is not a national affair? This means you need to have cooperation between national and multinational competition authorities. So competition authorities have a network of forums that they've created, both at continental level, which is the Africa Competition Forum, then there's the international network, and some of these are formal and some of them are informal. But more importantly, enforcement cooperation to control international unfair competition and restrictive business practices such as cartels, but also to protect intellectual property rights from being abused in different countries. Finally, also consumer protection. In the case of Kenya, competition protection, consumer protection is an international obligation, and society groups on consumer protection. So I think that would be the end of my presentation. I just want to conclude by saying that in order to have a competitive and inclusive business environment, we need to reassess the allocation of resources from less productive, which would be public enterprises, to more productive firms, which are SME, so that we can avoid concentration in markets. But more importantly, again, we need to improve the institutional framework and enforce antitrust laws in order to have a strong competitive environment. Thank you very much. That's the end of my presentation.
Thanks a lot, Daktari, and that was quite an elaborate presentation, I must admit. You gave us quite a raft of issues, and I like the 9 principles. Among them, actually, the one that came out most strongly for me was balancing competition and intellectual property rights. That's a very important one, especially during the COVID period, because you notice most of the producers of vaccines wanted to keep it to themselves. Anyway, as well as the issue of free and fair markets and free movement of goods, not only within our borders, but also cross-border. So I won't take much time to belabor upon what we presented rather, but I want to invite our third speaker, who is Mr. Boniface Makongo, who is also the director for the competition and consumer protection with the Competition Authority of Kenya. Mr. Makongo, good to see you. Karibu sana. Take it away.
Asante sana. So, and I don't have a PowerPoint presentation like my other colleagues, but I'll basically just take you through how we have enforced competition law during the COVID period. But before I go there, maybe just to give a background, I know Stephen had said something about our mandate. So the mandate of the authority is to promote competition and also protect consumers from unfair and misleading conduct. So with regard to protection of competition, essentially what we do is we investigate and sanction restrictive trade practices, We also investigate and sanction consumer complaints, and also we handle mergers. When people want to come together in the industry, they have to seek our approval. So essentially, those is what we do. But in addition, we have an additional mandate area around buyer power, which I will not be going into today. Now, with regard to COVID period, the key priorities of the authority when the outbreak was confirmed was first, of course, to keep our employees safe. Also ensure that service delivery is not impeded, because you realize that given the role we play in the economy, if we are not able to offer services, that has an impact on the investment climate in this country. And lastly, play our part in ensuring that the spread of the virus is prevented. So I'll take you through the key measures that we took as an authority based on our mandates. First of all, you will recall that immediately the virus was confirmed, a lot of players in the market all over the country started increasing prices, especially of foodstuffs and the product that became whose demand had spiked as a result of COVID. That is masks, sanitizers, and related products. So what we did is, pursuant to our consumer protection mandate, we issued a cautionary notice to players who deal in either of those products. So we were issuing the cautionary notice to manufacturers, to traders, retailers, and everybody else, essentially, who is in the supply chain of the products that I've just mentioned. And essentially, the provision of our law that we were relying on was with regard to unconscionable conduct. So the authority took the view, because we don't have a particular provision of the Act on price gouging, the authority took the view that these price increases were unconscionable, because you would find that somebody has purchased a product at a particular price, but just because there's an increase in demand, or there's an anticipated increase in demand, the price has been increased probably by 100, 200, in some cases even almost 1,000%. And you cannot explain, based on the cost of producing that product and also distributing it, how that price can be justified. So we did issue that. The other thing we did is we sent our staff members across the country. So we actually covered 43 counties. And the purpose of that was basically to sensitize the players in the industry, the various retailers across the country, of the importance of complying with our Act, especially the one, Section 456 on unconscionable pricing. And we also undertook some kind of monitoring. So we issued them with, you would have a base price. You tell us what your base price is. That is the price before COVID. And we did some monitoring for a few months subsequently to ensure that the prices, there's no price gouging essentially in the market. And that, from our perspective, was fairly successful, because we realized that the prices tended to normalize after that. The other thing we went in for is we also noticed that a lot of suppliers, in anticipation of a spike in demand, had started having exclusive contracts. So you have a scenario where the manufacturer and certain retailers or suppliers are having exclusive contracts, essentially to make sure that the products are not supplied, to other players who are selling the same product, or in some cases to have discriminatory terms. So that is also another issue that we issued an order to the players, alerting them to the fact that if you have exclusive contracts, that's a contravention of our Section 21, and we alerted them to the consequences if that conduct persists, and in our context, the law allows us to penalize up to 10% of the turnover. So that is the other aspect that we imposed at that time to address the issues of pricing around COVID. And also, lastly, there was one where we actually forced somebody to, or rather compelled an entity to a supermarket to refund, and that has been mentioned by one of the presenters, to refund and to refund the people who had purchased a particular sanitizer, whose prices spiked from around 150 to around 960 overnight. So those are some of the things we did. So because of those particular measures, we noticed that in basically a span of 3-4 months, the prices had normalized. And of course, also there were other measures like there were more players entering the industry to supply some of those things like the masks. And you've noticed the prices for both the masks and sanitizers came down considerably over the period. Now, the other issue we have, of course, COVID has affected the industry, many industries negatively. So going forward, we also noticed that as an authority that there was need to put in place measures to aid especially SMEs. So the first thing we've done here is we are in the process of actualizing block exemption guidelines. And the whole idea here is normally, if you look at the provisions of our law, if you engage in either price fixing or you engage in geographic market allocation or any other contravention where players come together with a view to either reducing production or related issues, that is normally a contravention of our act. But we noticed that there are certain sectors that had been very negatively affected by COVID. So what we did is to save especially SMEs from mortality, and also others which are not necessarily SMEs, but which were negatively affected, we are in the process of operationalizing these block exemption guidelines. And what they basically ensure is that if you have a market share of less than 30%, we allow you to engage in practices that would otherwise be a contravention of our act. So the sectors we're looking at here is aviation. And aviation, we're looking at the cargo transport, air transport, hospitality, pharmaceuticals, horticulture, and also private healthcare. Because these are sectors that our assessment determined that had been very negatively affected by COVID. And as a way of ensuring that both supply is sustained and that farms are revived, we are telling these farms that you can go ahead and engage in this conduct, which you set out in the guideline, which would otherwise not be allowed in a normal if normal supply was not, if we didn't have this kind of COVID scenario. The other thing we've come up with are joint venture guidelines. And here, our motivation as an authority is that we noted that because of the complexities posed by the pandemic, there is a lot of room now and for where farms want to engage in, some kind of joint ventures, including greenfield joint ventures. So basically what we've done is the guidelines basically allow farms, we are trying to minimize, the regulatory burden on farms that want to do joint ventures. And we're also allowing greenfield joint ventures to go ahead without seeking our approval, because otherwise those would amount to mergers and would have otherwise needed to come to the authority. So those are the issues we are looking at going forward, and our focus is to ensure that SMEs, especially because they've been very negatively affected by COVID, we want them to have a breather, to be in a position to restart business as we open up the economy. Now, the other issue I want to basically talk about is the challenges that we encountered. The key challenge that we encountered was, unlike countries like South Africa, where they have clear legal provisions on price gouging, we do not have one in Kenya. So we basically relied on our unconscionable conduct provisions in the Act. But I like to also to clarify that we're not fixing prices per se. We're basically just saying you need to do business with some ethical, standards, so that you don't overprice for products needlessly, which you cannot justify just because there's a pandemic. So it's something that happened in a short time to normalize supply. So that the issue of lack of a specific provision of the Act is something that we're looking at going forward, whether we can have an amendment of our Act, depending, of course, on the dynamics of COVID, to empower the authority in future to be in a position to address the issue, substantively, based on a provision of the Act. That was a key challenge, I would say, that we faced. Because we work very closely with the business community, the association, the various associations that they are, we did not encounter any challenge, in terms of sensitization, in terms of, getting our messages across because of that very close collaboration. Maybe the other issue that I would mention is that as an authority also, we realized that because of COVID, there was need to, to have a very close collaboration with other agencies globally, because things were changing by the month. Every month there are new things, there are new dynamics, and you get to learn how other agencies globally are handling the same issue. So that worked in our context because we are members of the International Competition Network. We're also which brings together competition agencies globally. We're also very active participants in both the International Competition Network and ISPEN, which brings together the consumer bodies globally. And regionally, we also work very closely with both the East African Competition Authority and the COMESA Competition Authority. So basically, that was very key around that time to address the challenges that were developing, and they were in a very dynamic way. And that helped us, to be in a position to address the challenges that were coming up around that time. So basically, I think that is all I had for you today. But I just want to mention a few things that came up in the previous presentations. There was an issue of Peter raised about independence. As an authority, we don't think that independence is a challenge, because as a state corporation, what you're looking at is operational independence. That if you're doing an investigation, for instance, in a particular sector, that there's no interference in that investigation, or that you're not compelled to make one finding or the other. So basically how our structure, how our authority is structured is that all the decisions that are made by the authority are made by the board. So the management reports to the board, and once the board has adopted that decision, it becomes operational. So we've not encountered what I would call interference from maybe other government agencies or any other arm of government. And I think that is something that needs to come out. The other issue that he raised was around the issue of government policies that appear to that are discriminatory in nature. One of our mandates areas is to advise the government on competition policy and consumer protection. So whenever we encounter a scenario where there is a policy that is being developed, because of the many interests that are in government, you'll always find a scenario where somebody or a group of players want a particular policy implemented in a particular way. Pursuant to that mandate, we advise the government and tell them that probably this particular policy that is being proposed should not be adopted for this and these reasons. So those people who have been following, for instance, the issues around cement and clinker, where there's been a proposal by one of the players that the price of clinker, the tariffs on clinker imports need to be raised, to spur local production because we have the capacity. We have advised on the effect of that, on what the effect of that will have on the prices that the consumers ultimately pay because of the dynamics that we have assessed in that sector. So those are some of the things we do. And essentially, our experience is that whenever we have advised the government, our advice has not been disregarded. So I think that is where I'll stop for today, unless there are questions. Thank you.
Thank you, Boniface. I guess questions will come during the plenary, but as we go on, I didn't know that actually the Competition Authority actually enforced a refund on purchase of sanitizers. I think that's a good move, and it just goes to show the extent to which the authority actually enforces and takes its mandate seriously. So take us to the plenary session. I want to invite Kwame Wino, who is our CEO, who will take us through the plenary session. Kwame?
Okay, thank you and good morning, everyone. So we've had 3 presentations. I'd like to thank all our speakers, our panelists for giving us quite some education around competition law, competition policy, and obviously as part of celebrating the World Competition Day. So we remind ourselves that the theme of this year's celebration is competition policy for an inclusive and resilient economy. So the logic of competition is just basically, one, consumer protection, but to make for a fair market in terms of competition, to allow for competition to thrive. So Stephen took us through Kenya's competition law, citing specific sections, and then gave us some examples of competition law questions that arose last year, or questions in competition policy that arose last year, citing various examples. And then we had the second presentation from Mr. Peter Mwencha, who gave us competition principles for resilience during pandemic periods, and he gave us 9 principles coming from intellectual property, institutional autonomy, and we had the third presentation from the enforcement challenges and the competition policy in Kenya. And here, Mr. Boniface Makongo, who's Director of Competition and Consumer Protection with the Competition Authority of Kenya, gave us examples of basically key measures that were taken by the Competition Authority as the pandemic, soon after the declaration of the pandemic, and of course its effects on markets, both demand and the supply side. And he mentioned something about the cautionary notices that were provided, conducting surveillance across 43 counties in Kenya, and of course, he cited some of the sectors that were most affected and what the vigilance that the Competition Authority has maintained. So I think we are glad that we've educated ourselves. We've settled on a few things, and obviously it's clear to whoever is, to the audience, that competition and proper competition law based on the right principles are actually useful, not only for making an economy efficient, but actually from the background of an economist, basically it protects consumers. And I think one of the things that it does, it makes sure that the market operates as closely and as efficiently as is possible, as not only economic theory states, but also because it's useful for the best use of resources. So the resources should find the best uses, and competition ensures that resources are used in ways that actually get the most value for all of society and actually enhance welfare. So now I'll open this up to I think the audience has been very, very patient. So I'll open this up to anybody who has questions. Please raise your hands. On the right, on the top of your menu, of your bar, there's a floating bar which allows you to raise your hands. Please raise your hands or send your questions through the chat box, which is also available to the left of it. I see there's some questions first already, but I'd like to first start with anybody who has questions. You can raise your hands, and then please state who you'd like the question to be, who you'd like to pose the question to, or if it's a general comment, please make the general comment, but do introduce yourself as well. So let me see as I read the questions whether anybody will have their hands up. Anyone? All right, okay, there are none. So let me ask the questions that I'll ask. I'll ask a couple of questions and then I'll go by each of the panelists to answer them in turn. So I'll ask, this question came from Edna Mogaka. And she's asking a question to Mr. Makongo. So the question says, how did the Competition Authority collaborate with the PPRA in pricing of items and commodities during early stages of COVID in our country? She says that PPRA has a MPI survey done. Does Competition Authority rely on the data, or they have their own MPI survey, or does the Competition Authority have an independent survey? So that's a question to Mr. Makongo. Let me go for the second, and then I'll come to the second question. Is from Hussein Dero, and he says that the main threat of competition is crowding out effect, where government locked out private sector from accessing loans in financial institutions due to confidence, trust, economies of scale. What mitigation policies adopted to avoid this unfairness? Okay. I think that's a question that can be answered by all the panelists. Could actually just make a point. Could make their comments on it. So let's start by reversing the order of responses. So this time I'll ask Mr. Makongo, please respond to the first question from Edna, which is specifically to you, and to the second question about the crowding out effect by government borrowing. Is Mr. Makongo here? Boniface?
Yes.
Oh, please go ahead.
Can you hear me? Yes.
Yes, we can.
So first of all, I'd like to clarify that we work very closely with PPRA, and that we have an area of concurrent jurisdiction or mandate in regard to collusive tendering. So we work very closely in investigating collusive tendering cases. But coming to the question of, and we have in that regard, for instance, completed successfully an investigation to do with poles, the poles that are supplied to our electricity providers. Now, with regard to the question on whether or not we relied on their pricing, we did not work with them with regard to that particular issue of the pricing at the initial stages of COVID. What we did is we adapted the prices that were there before COVID. So that is the pre-pandemic prices of the items we were looking at. And then we looked at now the prices that had then shot up subsequent to COVID. So our baseline was the prices before COVID because we noticed that there was no significant change either in the price of raw materials, in the cost of transportation, or anything else that would have warranted the kind of price increases that had happened. So that basically, that is how we approached the issue of pricing around that time. With regard to the next question around crowding out effects, I think this is my personal opinion. I think is that this is something to do with, I think, government borrowing, and I think one will be better placed to address this. I.e., if we borrow too much, therefore, of course, banks would prefer to lend to the government and not to the private sector, and that has an impact on our kind of, how the economy performs because people are not investing and all that. So I think this is an issue of wider government policy with regard to debt, but you're aware about our debt levels. So I don't think I want to say more about that. Maybe economists will be better placed to address that issue. Thank you.
All right. Thank you, Mr. Makongo. What about Peter? Peter, especially on the second question, or how do you think the public procurement regulatory authorities should cooperate with the competition authority to ensure that the bidding processes for public procurement are fair?
Thank you, Kwame. Can you hear me?
Yes, I can. Go ahead.
Okay. Well, I'm not a procurement expert, but if you go back to my presentation where I said we need to have what we call a more all of government approach, whereby first of all, disclosure of what the procurement rules are, because sometimes you find that in many cases, from what I've gleaned in the media, you find people complaining about change of rules, or sometimes even just basically cancellation of tender processes and whatnot. So that's one side of it. Like, is there transparency in this space? And if there's transparency, are all the players clear about the rules? So that's very important. But now when it comes to competition, in terms with the competition authority, I think this whole of government approach is very important, because if you go back to the issue about the independence of regulators and the operational independence, which is been repeated by Boniface, how do you ensure that regulators such as the Public Procurement and Regulation Authority work with this other regulator, cross-cutting regulators such as the Competition Authority, who have a cross-cutting mandate, across various sectors and across various markets. So I don't want to say that I have prescription, because like I said, I haven't really followed the procurement issues in detail. But what I can say is that I think there needs to be collaboration and engagement so that some of these issues which stick out can be addressed. But then let's not forget that some of the competitors do not compete fairly. And as you've seen also in the media, there's a lot of money, or I would put it, corruption in procurement. So that also needs to be addressed, because I think if you don't address corruption or these unfair competition practices, then and you can see, I think there was a case yesterday where somebody, I think, who is a procurement officer, he was found to have a lot of assets which he couldn't explain given his salary. So I think that contributes to all these challenges in ensuring that procurement is transparent and it's done in the manner that it's supposed to, or the law expects it to be done. So one of the issues would be that governance, or governance in the procurement space. How do you root out corruption? But then again, how do these bodies, bodies such as the Public Procurement Body and the Competition Authority, which has a cross-cutting mandate, how do they work together to ensure that this process is clear, and including also the courts system, so that when somebody files an appeal, when somebody feels like something did not go his way, or something that went wrong, how do you ensure that also the appeal is adjudicated in a fair manner? So it's a very complex area. I'm not saying that I can prescribe one solution, but I think I pointed out the issues that need to be addressed for people to be comfortable with and have trust in our procurement laws and processes.
All right, thank you. Steve, do you have any comments?
No comments at this moment.
All right. Okay. Well, yes, Ms. Kongo asked me to respond to the question by Hussein. And yes, I think the question is, the comment is that if government borrows too much domestically, in our case, of course, it's borrowing quite a bit based on what the size of the deficit, which is about 6% of GDP. That's really, really high. It's unprecedented. It's much higher than what is even considered safe, which is anything below 3%. Obviously, that has an effect. If the borrowing is domestic, it has an effect in the sense that it's displacing private sector borrowing, because many corporations in Kenya, or rather many banks or financial institutions, would prefer to lend to a safer person such as government, to a safer entity such as government, which obviously pays, but also it's safer and easier to manage that kind of lending facility. That has an effect on displacing the private sector. And obviously then that means that investments domestically do not take place as they would, because instead government is taking some of the money that the private sector would have preferred to do. So its government is outcompeting private sector, and it's been done. It's been seen. So it's not a direct competition problem, but perhaps it's a question of actually fiscal policy and its effects. Because one of the things that has happened in the year 2015, for every 100 shillings of government, of public lending, of lending by all banks and financial institutions, the government of Kenya only took in, I think, 24 shillings, 25. Last year, based on the number that was declared, for every 100 shillings, about 34 went to government. So meaning that 9 percentage points change within 5 years shows that government is borrowing more and more of the resources that are available. And you can therefore make the correct claim that it is displacing private sector. So that's the one point. The competition point, however, comes here, and this is a sensitive point which I think we need to mention. The competition point comes here. Government public procurement, even of debt, should be a competitive process, where competition means government should try as much as possible to make the lending institutions compete by asking to make sure that the lowest government borrowing is reduced. In which way? The government of Kenya borrows, I think, about 10 or 12 billion shillings every 2 weeks through the auction system, which is managed by the Central Bank of Kenya. Our view at the Institute of Economic Affairs is that if that auction system was completely competitive, complete competition in terms of an auction system well designed for competition, it would reduce government borrowing, the percentage of the interest, by maybe 1 percentage point. And that's a lot of money. If you talk about 1 percentage point lower for 20 billion shillings of borrowing, it's saving the public, I think, close to 150, 200 million shillings. That's significant. So our view is that there should be more competition and more transparency in the auction process through which government procures loans. So that's a competition question. Whether it's within the jurisdiction of the Competition Authority, I suspect not, but that doesn't mean that we as Kenyan citizens should not raise it, and we at the IEA intend to raise it in Parliament. I think that process is not, in our view, as transparent as it should be, because part of what makes markets function efficiently is transparency to allow for that competition to occur. So that's the first one. The second point of competition is, a couple of years back, the National Treasury, wanting to generate competition, but also wanting to generate an opportunity for the public to also lend money to the government directly, brought in what they were calling the M-Akiba, I think, which was a facility that allows allows, say, a Kenyan to use their M-Pesa to buy government bonds directly without having to go through banks. The logic was this: a Kenyan today saving money with banks would get at most about 2.5% on your saving for a whole year. So if you save 100 shillings in a bank in a savings account, you will get about 2.5% for a whole year. If, however, that same bank takes you 100 shillings and buys government bonds, they're getting sometimes as much as 9%. So basically, the spread is such that banks are making nearly 6% by just taking your money and keeping it and saving it to government. The intention of the Treasury at that time, and Henry Rotich, the Cabinet Secretary, was to make this process more competitive by allowing people to be able to buy those bonds directly, and obviously that would lead to increased competition. That was not supported by the banking institutions and financial institutions, but we understand where their interest is. Again, in terms of using competition policy, I'd like to plead that part of making a resilient economy is, in our view, for the Competition Authority to alert government to the mechanisms that would allow the government to apply competition principles which it imposes on private sector, on government itself as well. So sorry for going outside what the question was, but I think it's a very important question, and it's an enduring one. I think we're about to close, so I'll come to our final round of questions. I haven't seen any other questions on here. Does anyone else have another question? I haven't seen any more questions, Steve, so I'm not too sure whether there are any other. Let me see. There are none. So what I'll do now is I'll ask each of our panelists to make their final comments, and I'll again reverse the order. So I'll start with Peter, then I'll come I'll start with Peter. No, I'll start with Stephen, then I'll go to Peter, and then I'll ask Mr. Makongo to finish. So Steve, please make your final comments. Any final comments?
Yes, comment. Thanks. And I like the point you made about government being actually subject to competition policy rules and regulations insofar as acquisition of or borrowing is concerned. That's a poignant point which we'll pursue further. But in closing then, I think it's important to note that we've realized that competition actually plays an essential function in the market, which allows then for enhancement of consumer welfare, noting actually the pandemic period. Then we actually need to ensure that all the principles of competition policy and law are actually enhanced going forward, not only during the pandemic period, but also post-pandemic. So I just want to urge all of us as we commemorate this year's World Competition Day to bear in mind that competition is key towards ensuring that both mine and your welfare are taken into consideration. Thank you.
All right, Peter.
Thank you, Kwame. I just want to thank you for organizing this interesting and insightful session. It's been quite interesting to hear the different perspectives. What I want to say is that from a personal perspective, my experience is that competition is something that we're all part of. We've been experienced cases where we've experienced unfair competition practices, and sometimes we were able to find alternatives or resolution, but in most cases sometimes this is not possible. So what I would encourage is two things. There's from the government side or from the public sector side, it would be interesting to see what the competition authority and the government as a whole, what they do going forward in terms of the post-COVID recovery, because our economy is really suffering. There's a lot of companies that have exited. There's a lot of companies that are struggling, lots of unemployment. So we need a more robust measures, more creative government interventions to forestall or to revive the economy and to ensure that our economy is inclusive. Bearing in mind that our country is one of the most unequal countries in the continent or in the world. So the divide between the rich and poor is very big. So we need an economy that works for everyone. So that's very important. Secondly, coming from the civil society, this is something that is close to our hearts, competition, and in particular competition authority. We as CATS are very keen on these issues. So it'd also be good as civil society, as academia, which I'm also part of, to also engage more robustly with stakeholders on these issues that affect all of us. So so this for me is a call for civil societies to be more robust and to engage more clearly and deliberately on these issues so that we can protect consumers, but we can also ensure that we have an economy that works for everyone. Thank you very much.
Right.
Yes.
Thank you. Yes, Mr. Makongo.
Yes, thank you very much. I think just to, based on what Peter said, just re-emphasize the fact that the authority is committed to addressing especially the challenges posed by COVID to SMEs, because that is the bulk of our business, and we want to make sure that our entrepreneurs are not constrained by regulation and forced out of the market. So that is why we come up with both the joint venture and the block exemption guidelines. But generally, again, as an authority, we've noticed there is an upside, for instance, in mergers. So that would imply that the economy is recovering, after the measures have been taken away. In addition, I think apart from that, we are also focusing on challenges, the competition issues that are posed by platforms. That is a global topical issue, and we're trying to see how to address those in the local market. So that is another area that you'll be hearing a lot from us, because you realize, for instance, that Kenyans are very interconnected. We are relying more and more on the digital platforms for for purchases and related issues. So we, as an authority, are looking at both the competition issues those pose and also the consumer protection concerns that arise from use of digital platforms for purchase of goods and services. Lastly, basically just to thank Institute of Economic Affairs for organizing this webinar, and hope that you will organize many more going forward, and we shall be willing and ready to participate when called upon. Thank you very much.
Okay, thank you very much, ladies and gentlemen. So let's remind ourselves that part of what we're doing today is to celebrate World Competition Day. Our theme was competition policy for an inclusive and resilient economy. And we've had 3 presentations from Stephen Jairo, who gave us a background, competition principles, which are very, very important. And obviously, we also has Mr. Boniface Makongo telling us what the enforcement measures have been, and obviously the surveillance over the difficult period for COVID. So we've learned, speaking for myself, we've learned quite a bit. On behalf of the IE, I'd like to thank all of them for taking time to be here, and for the audience as well, and the questions that you posted to us. But I'd like to conclude with two things. One, I think nobody can argue anymore that good competition platform or an environment is good for an economy, partly because it benefits consumers, it benefits small farms, it benefits big farms as well. I think it also benefits government itself. So that's the first one. Second, if you think about it in Kenya, the government of Kenya plays an extremely important and large role in the economy through specific government institutions, but also through the state-owned enterprises which are driven by public money. The efficiency of the economy will therefore be suboptimal if competition policy and competition authority is directed only at private sector firms. And so one of the things that we think is essential for resilience of the Kenyan economy, not just after COVID, but for the long term, is to ensure that competition authorities focus on ensuring that public sector firms and all institutions in the public sector also apply the same principles that are being for which, or rather the surveillance or that are being applied to the other, enforced with respect to private sector formations. So I would like, for instance, of course, we also mentioned the question of the public procurement, and I think public procurement in Kenya is one of the areas in which competition and greater competition focus would be important, because in our view, every time we hear about public procurement fraud, it is often because there was bid rigging or there's insufficient information, and in my view, those are also essential markets. So among the things we need to ask ourselves is, while the Competition Authority does a fantastic job, largely from what we've been told, I think it's time for us to actually also ask ourselves, how does the Competition Authority help procurement agencies to ensure that those systems are actually working well? Because that's part of the resilience of the economy. The government of Kenya is a major buyer and also a major producer of some products for which and services for which increased competition and the efficiencies that come with competition and the principles that have been enumerated to us would be essential. So I'd like to thank you all for this, and to make the undertaking on the part of the Institute of Economic Affairs that will continue to be an institution tracking Kenya's competition policy, trying to create public education, but also opportunities such as this for discourse around topical issues in the competition policy law and competition policy and law landscape. So I thank you all for being here, and thanks to our panelists who've done a fantastic job in educating us today, and everyone else. Continue to celebrate competition in the day-to-day and for another year before we meet again next year. Thank you very much and have a good morning. So let's clap for our panelists. Thank you very much, everyone, and have a good morning. Thanks. Okay, thank you and have a good morning, everyone.
Thanks, everyone.
Thank you.